focus is climate related. Thanks.
All right, good evening, and welcome to the Hudson Area Library and our first 2026 local history talk. This is on freedom of speech in New York by Albert M. Rosenblatt. Because I'm wearing my glasses, I can't see. So this is the first in our series of Leisler lectures for 2026. We collaborate every year with the Jacob Leisler Institute for Early New York History on 4 lectures throughout the year, and we're very happy for this collaboration. And before we begin, I just want to tell you, as usual, what our next event is, which is February 1st, Sunday, February 1st at 2 p.m., The Long Road Home, Genealogy and Race in the Hudson Valley. And that's going to be a panel discussion with the African American Archive of Columbia County. And they're doing a 3-part series speaking about history in 2026, also with us. Some of the panelists are Deb Bruno, who is the author of A Hudson Valley Reckoning, Discovering the Forgotten History of Slaveholding in My Dutch American Family. And if you haven't seen that book, it's spectacular. It's gotten on the bestseller lists everywhere. Also another panelist is Ellen Meyer, and she's a descendant of Deborah's family that were enslaved by her family. So we're going to be selling copies of Mrs. Bruno's book, and should be a great event. And now for tonight, I'm going to introduce David William Voorhees, who's the co-founder and director of the Leisler Institute. He'll be introducing the judge. David is a very modest person. I'm going to introduce him a little differently now, because some of you don't know. He's a very modest person, but I want you to know that he is a Knight of the Order of Orange Nassau, having been knighted, Virginia knows, by the Consul General of the Netherlands in 2010. So, Sir David.
Well, thank you. Thank you, Brenda, for the introduction. It is again with appreciation that I thank the Hudson Area Library for hosting the Jacob Leisler Institute Peter Van Dyke Lecture Series. This series, named for late Institute benefactor Peter Van Dyke, introduces the latest scholarship into colonial New York and New Jersey. These lectures are made possible through the generous support of the Van Dyke Family Foundation, the Hudson River Bank and Trust Foundation, and the Bank of Greene County Charitable Foundation, as well as by individual donors. This evening's speaker is Judge Albert Rosenblatt. Judge Rosenblatt served as an associate judge on the New York State's highest court, the New York Court of Appeals, after serving as a New York State Supreme Court Associate Justice. A graduate of the University of Pennsylvania and of Harvard Law School, Rosenblatt was instrumental in creating the Historical Society of the Courts of New York. He has written widely on New York law and culture, including producing, with his wife Julia, the acclaimed opening statements, Law, Jurisprudence, and the Legacy of Dutch New Netherland, a work to which I was honored to contribute an essay. He now teaches at New York University Law School. His talk tonight on the Peter Zenger trial is particularly relevant in today's political climate. Please help me welcome Judge Albert Rosenblatt.
Okay, how's that? Is this, the voice carries better this way?
Yeah.
Okay, good. Yeah, it's so good to be here, particularly to come up the road from, I live in Poughkeepsie, we're from Dutchess County. And my wife, unfortunately, couldn't be here. She's a little bit under the weather, but she'll be fine in a day or two. I got to meet David Voorhees when my wife and I did a book on Dutch New York, having come to learn during the Henry Hudson 2007 celebration that we as New Yorkers were Dutch for about 40 years before we became an English colony. And so our Dutch roots, so to speak, I mean the corporate we, I'm ethnically not Dutch, but I say we Dutch because we're Americans and we at one time were English, and before that we were Dutch from 1620s or so to 1644. So we wound up writing a book about the jurisprudence, the law in Dutch New York, and was able to meet and consult with great experts like David Voorhees and the people in the New Netherland Institute, which I commend to you. So tonight's talk seems thoroughly apt because, as attributed rightly or wrongly to Mark Twain, history rhymes. That doesn't mean that it's going to be exactly the same, but there's a certain rhythm to it in which what happens today, we said, you know, that sounds very familiar. When you go back in the pages of history, this is not the first time that licenses are being threatened and that free speech is being threatened. So the Zenger trial is celebrated as one of the great landmarks of freedom of the press in the United States. I can tell you a little bit about the Zenger trial because I looked at it and studied it to a degree. And I think it's apt to call it one of the landmarks in American free speech, but I think in a way it's something more than that, and we'll get into that in a moment. Before we get to Zenger and the Zenger trial itself, I thought it would be useful with this great clicker here. Okay, there it is. So the Zenger trial is 1735. But just see if you can absorb all these other dates so that you appreciate the bookends and just the historical context. So a couple of dates are known, they're especially important. In 1787 is the United States Constitution drafted in Philadelphia. And that's the Constitution by which we live. And when we as Americans say today, that's in violation of my constitutional rights, we typically mean the United States Constitution, which was drafted in 1787 in Philadelphia, but ratified in Dutchess County in 1788, the following year. But that's where we get our notions of the Bill of Rights. And in terms of the Bill of Rights, which is part of the United States Constitution, can I recall for you some of the Bill of Rights? First Amendment, freedom of religion, no establishment of religion, free speech, free press, freedom to petition, freedom to assemble. So the First Amendment isn't just one freedom, it's disestablishment and freedom of religion on one side. And as far as speaking, free speech, free press, free assembly, and free petition. So it actually has a cluster of rights in the First Amendment. When James Madison promulgated the First Amendment, whether he put it there purposely because it's the most cherished, we don't know. Maybe it's not a coincidence. The Fifth Amendment, due process of law, as a lawyer and a judge, to me that's as important as any. Sixth Amendment, right to counsel. Eighth Amendment, protection against cruel and inhuman punishment. So there are a lot of these amendments. Second Amendment to some people, the right to carry guns. So all these amendments count for an awful lot. They were not in the original Constitution of 1788. But New Yorkers made such a fuss about their absence that we were resisting becoming a member of the Union because it didn't have a Bill of Rights. And from Dutchess County, where we were holding a ratification conference, we sent word to James Madison, the architect of the Constitution, saying, we don't want to adopt this Constitution because it doesn't have a Bill of Rights. And he writes back and he says, all in good time, I guarantee you that in the first Congress, we will promulgate a Bill of Rights. And we trusted him. So Madison was good to his words. And I think at some point, Americans are going to start to figure out that James Madison may be counted as the principal father or founder of our country, because he basically was the primary author of the United States Constitution. That's different from another constitution, which was earlier by 10 years. Does anybody know what that constitution is? That's the Constitution of the State of New York, which is an extraordinary document. We declared independence from England, George III, on July 4th, 1776, and we're going to be celebrating the 200th anniversary of that next year, and there are already groups starting up. I know that my friend Gully Stanford over there is active in a lot of the events that are going to take place, and I know there are going to be events here in Columbia County dealing with the 250th anniversary of the Declaration of Independence. That's July 4th. That's the fireworks and all the celebration of July 4th. That's when we separated from England. What did we do on July 5th and on July 6th and on July 7th after we were no longer governed by England? We said, well, we need some kind of a charter. We need bylaws, a constitution. We need something to govern ourselves. True it is, no document in the history of the world had ever been written in which people govern themselves, because we were only governed by monarchs and kings and queens and emperors and sultans and so forth. So they called on one of the one of the people with great wisdom and great, for whom we all had great admiration, and they said to him, who is 31 years old, "Here, Mr. John Jay, here's a quill. Write us up a constitution about how we're going to manage our lives, how we're going to elect people, how we're going to function as a government. True, no one's ever done it before, but come back in 30 days and just do the best you can." So he enlisted two young chaps, both under 30, Gouverneur Morris and Robert Livingston, and the three of them sat down. They weren't actually sitting. They were actually running, because we were at war with the English when they wrote the Constitution in 1777. It was the early part of the Revolutionary War. As you know, the war did not end until 1783 with the Jay Treaty. So John Jay, Gouverneur Morris, and Robert Livingston write up the United States the New York Constitution in 1777, and a lot of the ideas in the Constitution of 1777 of New York fed into the United States Constitution of 1788 and 1791. And James Madison credited New York with giving them some of the ideas. So there we are. So that's a little sketch as far as the late 1770s, 1780, and so forth. I have 1644 there because it was 100 years before the Zenger trial, in which John Milton, who we know not so much for his outcry against licensing by the Crown, we know him for Paradise Lost, the great Milton poet. But he was very outspoken when the Crown tried to stifle speech, and when rulers try to stifle speech, they have all kinds of ways of doing it. If they are descended from the divine right of kings, they just say, "Shut up or we'll kill you." Simple. That's been going on for a long time. Another way, a little more sophisticated, is to require a license. And as long as the licensee says what the ruler wants, the license is okay. And as soon as the licensee starts saying things that the ruler does not like, they yank the license. Does that sound familiar? Well, need I draw pictures? Okay. So that's why I mentioned John Milton here, because although his primary fame is with Paradise Lost, he was also part of that. We also mentioned New Netherland because we get some of our ideas in terms of the rule of law from New Netherland. New Netherland gave us, I'm going to say, one of the tributaries for freedom of religion. And when the Dutch got here in the late 1620s, the first governor, who was an employee of the Dutch West India Company, his name was Verhulst. Verhulst, am I okay?
I think so.
Okay, Verhulst. And they give the Dutch West India Company in the Netherlands, gives Verhulst his marching orders. And he say, you're going to cross the ocean, you're going to come to a place called New Netherland, and we're going to make it a shipping outlet for us in the Netherlands. Now listen up, Governor Verhulst. 1, we are not conquerors. We're not here to conquer Native Americans. 2, we're not here to twist anybody's arm into the Dutch Reformed religion. We are traders. As Dutch, we just want to make money. We're not here to twist arms. We're not here to do politics. We're not here to kill. We're not here to conquer. Those papers, the Verhulst papers, are in the Huntington Library in California, the orders to Verhulst. But I just mentioned that because I think we can all feel pretty good that we are really descendants of the of Dutch New Yorkers, and our ancestry goes back to that era, even though the folks in this room are from, maybe your ethnicity might be from Sweden or Scotland or Poland or Germany or wherever, but in that sense, we're all Dutch. So with that in mind, I'm now going to get to the Zenger trial itself and tell you a little bit about what happened. So let's go to the slide rule here. Here we go. That's a neat picture. It's a little bit inaccurate because actually there were two judges. Why two? I don't know. There were some strange doings in those times. They had 2 judges. We now have panels. The United States Supreme Court is 9 judges, as you know. On my court, the New York Court of Appeals, there were 7, 4 women and 3 men, by the way, when I was there. The next level court is the Appellate Division, 5 judges, but there they had 2 judges. And there they are, 3 of them. And we're not sure who that is. It might be Zenger's lawyer, whose name was Hamilton. Not Alexander Hamilton, but Andrew Hamilton from Philadelphia. And it's the artist's rendition of what the courtroom may have looked like. Don't know, a lot of it is, I think, imagined. Public Library. There's John Milton, who, in addition to his poetry, carried on a campaign against the Crown and the notion that the Crown started licensing publications and telling people they couldn't publish anything unless they got a license from the Crown, which the Crown could revoke at any time if the Crown didn't like what was being said. Handsome young dude, was he not? Yeah. And this is, interestingly, this is from the Gilder Lehrman Society. That's the newspaper that Zenger printed. And I guess they found a copy of it. That's the weekly newspaper that so antagonized the governor of New York that they tried John Peter Zenger for a crime called seditious libel, we have libel laws in the United States. It's hard to libel a public official in this day and age because we value political speech. And as you know from reading the newspapers, they can say pretty much anything they want about any official of the government, no matter how high, and they can be protected. The courts will protect them, and by and large, they've done so. But that was not the case back then, and we'll get into that in a moment. But that was the newspaper. Now there's another depiction of it. There's Andrew Hamilton speaking for Zenger, and the two judges were James Delancey, who was a very important judge in New York at the time. There's Delancey Street in Manhattan, which I guess you've been down there. It used to be kind of a grubby place. Now it's sort of nouveau rich, isn't it? The rich people now live in Delancey Street. Anybody been down there recently? Have you? It's now the high rent district? Okay. Used to be hot dog stands and stuff. I'm running a little bit ahead of myself, but you can look at this and feel pretty good. This is what we did in Dutchess County, we in New York State. When we refused to sign on to the Constitution, we said, we will sign on, but this is what we want in the Constitution. These were our recommendations as New Yorkers. So let's talk about the Zenger trial itself. It goes like this. During the English colonial period, which ran from 1665, when the English shoved out the Dutch, until 1776, when we got out from under the George III for about 100 years, that was a little less than 100 years, we were ruled by governors, and we were English. And if you were to stop any of us in the street walking around in 1720, 1730, 1740, 1750, we would all say, we are English. We don't live in England, but we are loyal subjects of the crown. We're all English. And we would mean it. But things started getting sour. When we're in junior high school, we hear the phrase, taxation without representation. We felt as New Yorkers that we're being taxed, but we had no representation in the English Parliament. And this began to stew, and little by little, the Patriots wanted freedom from England. We petitioned for freedom from England, and George III and Lord North said no, and little by little, the people in Pennsylvania, in Massachusetts, Sam Adams, for whom we raise a mug every now and then, was among the most ardent of the Patriots, those in New York, but Massachusetts was where some of the hotheads were, and New York and Pennsylvania and the other colonies. We all got together and formed an army that was led by George Washington. And we eventually prevailed. But my point on that is that we were governed for 100 years by governors. How did the governors get their power? They weren't elected like today. The governors were appointed by the crown, naturally. If the crown has a colony and we're all English and we're an English colony, well, obviously the crown is going to appoint the governor. And we had a succession of governors, some good, some bad, like any succession of governors anywhere. They were English. They treated us as English subjects. Some were harsh, some were not. And the Zenger story opens up when the governor comes to New York to replace the previous governor. This is in the 1730s or so. And this governor, Cosby is his name, C-O-S-B-Y. He says to the old governor, well, I'm the new governor. I'm here by orders of the crown. Everybody knew that the crown said, okay, we're putting in a new governor. So Cosby comes in, riding in town, says, I'm the new governor. And he tells the old governor, nice meeting you. You know, you can go back to England. You've done your service as governor. By the way, I want half your salary, because I was appointed 3 months ago. It took me this long to get here by the time I got my whole act together. And I was appointed 3 months ago, so I want half your salary because I was governor. Whereupon the old governor says, what did you ever do as governor? Nothing. And the old governor says, okay, tell you what we do. I'll give you half of my money as governor if you give me half of what you earned while you were in England. So they disagreed, and they went to court, as people would do in those days. The court ruled in favor of Cosby, the new governor. 2-1. The dissenting vote was by Judge Morris. Well, the new governor took very little time in getting rid of Judge Morris because governors would appoint judges. The notion of the independence of the judiciary was there to some degree, but people like Cosby could still kick out judges. So the independence of the judiciary is something that we've been fighting for in this country for a very long time. And if there's anything that defines the judge, the good judge, the virtuous judge, to which one aspires, it is independence from the government. The judge is not the agent of the government. The judge is the agent of the law. That's the rule of law. And this is what was breached when Governor Cosby kicks out Judge Lewis Morris for voting the long way. But being Judge Lewis Morris, obviously a person of means and a person of clout, he and his friends gather up and they form the newspaper, which we saw a little while ago. That newspaper, the Weekly Journal. And the Weekly Journal then starts writing articles critical of the governor. Here we go. So now the governor has it in for everybody on the staff of the Weekly Journal. But being bullies, which is what they were, they figure the easiest target, the easiest guy to convict is the printer. Not the brains behind the outfit, but the printer, because they can catch him right in the act of printing. It might take a little more effort to catch the people with the ideas, but the printer they can grab. So they went before a grand jury, and 3 grand juries refused to indict the printer. Does any of this sound familiar to you? So there we are. 3 grand juries refuse. And what does the governor do? He goes to the so-called Justice Department, to the new Judge Delancey, and he gets an arrest warrant for Peter Zenger, and they lock up Zenger because they set bail so high that neither Zenger nor anybody else could meet that bail. So Zenger is in jail, and they go to the trial. So here's the trial, and now I'm going to tell you something about seditious libel. So I'm taking a little bit of a detour, but I think you have to understand what libel is and what sedition is to appreciate what's going on here. Sedition, an act of sedition means to go against the government. Seditious, treason, and so forth. Libel means when you speak it. Seditious libel means speaking, libeling the government in such a way as to bring it down. That's a criminal act. And truth is no defense. So that while today, if a newspaper publishes something about a government official that's true, and the government official doesn't like it, truth is a defense because we have sanctified what eventually became the First Amendment, freedom of the press, and free speech, but not then. As a matter of fact, the Judge Delancey instructed the jury, and juries are supposed to do what when the judge gives them instructions. So I was a trial judge for about 10 years or so, and I would instruct the jury, in which I would say, okay, ladies and gentlemen, this is a trial involving a claimed contract between two people. Two people are able to make a contract if they both agree for mutual consideration, and it's up for you to decide, did A have a contract and an understanding with B? If so, the next thing for you to decide is, this contract called for A to do such and such. Did A deliver on the contract, or did A breach the contract? That's for you to decide. I've just told you the law, then you come back with your verdict. I've just condensed it to, something very, or in a criminal case, and say, ladies and gentlemen, this person is on trial for murder. Murder is defined as A intentionally killing B. The defendant claims it was an accident. The district attorney is claiming it's intentional murder. It's up to you to decide whether this was an accident or whether this is intentional murder. For you to find the defendant guilty of intentional murder, you must find that the defendant had the weapon, pointed it with the intent, with the wish, the desire that it shoot, and that it not harm or maim, but that it kill the victim. If you find that, your verdict would be guilty. Anything less would be not guilty. So that's what judges do. So what I just told you now is going on hundreds of times a week all over the United States. So what did Delancey instruct the jury? If Delancey were not Delancey, and if he wanted to be fair about it, which he was not because he was a tool of the king and the governor, Delancey said, there's only one question, ladies and gentlemen, that you need to decide. One question only. Did John Peter Zenger publish these statements critical of the governor? That's all you need to decide. Now, ask yourselves what kind of a slanted charge that is. The lawyer for John Peter Zenger stands up during his summation and he says, ladies and gentlemen, we admit doing the publishing. We admit printing it. But we ask you to find our client not guilty because it's the right thing to do. And because he was speaking the truth. He sits down. The jury comes back, not guilty. Now, that's the Zenger trial. Why do we think of the Zenger trial as being one of the great signposts of free press and free speech? Because they overrode what Judge Delancey did and they came back. But I would say that it's a bit of a misnomer to call the Zenger trial the championship of free speech. I would say it's the championship of trial by jury, in which juries are able to nullify the actions of tyrants. And there's a fascinating little side note to this. I wouldn't expect you to know any of these things because it's pretty arcane. New York's first constitution was written in Kingston in 1777. We were born in New York, in Kingston, in 1777. John Jay, Gouverneur Morris, and Robert Livingston wrote the Constitution. And interestingly, it did not have a Bill of Rights for reasons that we can maybe talk about. They didn't think it was necessary because they said, why do we need a Bill of Rights? We're the people. Well, we've learned better. But they did include in this first New York Constitution, they included one right and one right only. The rest of the Constitution was who gets elected, who served, the Senate, the Assembly, on and on and on, the stuff of the Constitution, black letter law. But when it came to rights, they only listed one right. What was that right? The right to a jury trial. Isn't that fascinating? Because they knew that juries were a bulwark against tyranny. I thought that was just remarkable. I shouldn't say the only right. There was one other right that they dealt with obliquely in New York's first Constitution, and that was freedom of religion. And we got some of that from the Dutch, in which in New York's first Constitution, we said separation of church and state. No minister may be a public official. Interesting. That's Jefferson's wall of separation. Interesting. And since that time, of course, separation of church and state has been one of the bulwarks of America. And in the First Amendment, disestablishment, the first words of the United States Constitution, the Congress may not establish any religion nor prevent the free exercise thereof. So the First Amendment, religion has two prongs. One, no established religion. Two, free exercise. They are very different. They're both sides of a same coin, so to speak. So I think I think for time, let's open this up to some comments or observations and make it sort of participatory. And that way I'm not just up here giving a soliloquy. How's that? Can pass this around or? Yeah.
What was Delancey's response to?
I'm sorry?
What was Delancey's response to the jury's verdict? Was he still a despot afterwards?
Oh yeah, he was still important. There was the verdict was the verdict. Life went on. Delancey was still very important. He was one of the most important judges of that period. I don't know the answer to that. I guess he had to take it in stride. He obviously was not happy, but we were strong enough then to abide a jury verdict. And I think when we speak of freedom of the press, the Zenger trial didn't stand so much for freedom of the press as it planted the ideas that eventually found its way into freedom of the press in the First Amendment. But what did Delancey do? Personally, I don't know. Might be a good, Ms. King, you teach at Ulster and Green Community College. You want any of your students to look into what happened with Judge Delancey in his life? Did he live okay? Did he go sailing? Did he go target practicing? What became of him? I imagine he lived out his life as a very prominent big shot judge.
So there was no way for
I'm
the
guessing, huh?
government.
Yeah.
There was no way for the government to appeal that verdict.
No. The notion of an English jury having the final word goes back a long time. This goes back to English statutes. And that's why trial by jury was one of the most prized of all of our notions about liberty and freedom. It almost all goes back a little bit to the Dutch, but 90% to the English. The English common law, the writ of habeas corpus, that no government may hold anyone, confine anyone, unless a judge says, okay. That's, you're allowed to confine him because you have good grounds. Does any of this sound familiar?
Christy Noam doesn't know
About hiding people from judges? Wow, okay. So anything else? Yeah.
I just wonder how much freedom of speech was part of English common law.
Yeah, well, that's why I went back to Milton in 1644. So at least that far. And I'm going to say probably goes back before then. Maybe the Petition of Right may have had some language about speech. But, we are children of the common law. And our legacies of freedom are basically English. I say that as an American judge because in our own decisions, once in a great while, maybe once every year or two, we would cite English cases. They've all been supplanted by American statutes, but English common law is still, that's the soil we live on. That's the aroma that we breathe. It's good stuff. Yeah.
Can I ask you how impactful the decision in the Zenger trial was within the historical context? Like after 1735, this jury delivers this. Is that felt within New York or even the broader 13 colonies at the time in terms of we can now criticize our government?
Interesting. Great question. I think the answer is largely yes, with a few dark spots. 1777, no, the Zenger trial is, as we know, we have the date. 40 years later comes the United States Constitution, free speech. 1777, we put in jury trials in our state constitution. Then comes 1798. Does that, I wouldn't expect you to know what importance that date holds. But one of our favorite American patriots, John Adams, was President of the United States, 1798. And maybe like other people in charge, even John Adams, whom we revere in many ways. We had McCullough's book was a bestseller for a long time. Even John Adams was irritated at the thought of he was having hostilities with France, and he thought it was un-American to criticize the United States government when we're having hostilities with France. If you're an American, you shut up and stop criticizing, keep your mouth shut. So they pass the Alien and Sedition Laws of 1798. You can go to your little thing there and pull out the Alien Sedition Laws of 1798, and we're right back again. Seditious libel. But, to answer your point, when the United States Congress wrote the Alien and Sedition Laws of 1798, as part of that law, they said truth is a defense. So we had grown up a little bit. Isn't that fascinating? That we took the lesson from the Zenger case and stuck it right in our own Alien Sedition Laws of 1798. And so I looked up a little bit about Adams because we like Adams. He was by and large, he was a great American. And by the way, Adams was such a good lawyer that some of you may know, he defended, in the Boston Massacre, he was a good enough lawyer to defend the British shooters to establish that it wasn't quite the way many people believed. So he was a good man. And he goes down in his own diary, or maybe in one of his wife's diaries, that he thought this was his gravest mistake. Or I think he said, I didn't think it would have such bad repercussions, or something like that. So, of course, we give him that he knew better. My guess is if he had to live his life over again, he would not have asked the Congress to enact those laws. But the United States government, far more good than bad over 225 years, has enacted some laws that have been monstrous. The United States Congress gave us the Fugitive Slave Act of 1850, in which federal commissioners, these sort of half-baked judges who aren't real Article III judges, they were paid to write orders grabbing blacks off the streets and sending them back to North Carolina, to South Carolina and Georgia, and they get paid in accordance with how many people they sent back. Does any of this sound familiar? No. So history rhymes, and we learn a lot, and hopefully we get better each time. We have to remember our lessons, but we try to get better. This is my friend Gully.
So a double-barrel question, Judge. How were juries selected in the mid-18th century? And secondly, it appears that the cases that we hear of where First Amendment rights are violated right across the board are being adjudicated by judges with endless appeals that take us pretty well everything up to the Supreme Court seems to be the order of the day. So two questions. One is how were juries selected? Why has
How are judges selected?
juries selected? Then why has the role of the decision maker seems to be shifted to judges now? And do the people have any say in the determination of these cases?
There was a time, and it was a short time, and it's always puzzled me that juries would determine the facts and the law. Today, lawyers in this country would scratch their heads saying, how is a jury going to define homicide? They wouldn't begin to know, how is a jury going to define a contract? On the other hand, it wasn't so crazy. What they did was they tell the jury, here's what happened. You guys decide, make up the law. Make up what you think is a good law. Make up what you think is a good definition of murder and whether it happened here. We don't do that anymore. Right now, juries decide only fact in accordance with instructions from judges. That is all by statute. After the jury reaches a verdict, a judgment is entered, and there can be appeals. In criminal cases in the United States, anybody who's convicted of any crime, even minor crimes, not spitting on the sidewalk, but crimes that carry jail time, can appeal and get a free lawyer. That's an American ideal, you get a free lawyer. Anybody who, and they get not only do they get a free lawyer, but they get a free appeal to the first appellate level in New York and in most other states. To get to the state's high court, that's a decision of the high court, but they get one appeal to an appellate court in New York. I don't know, Gully, if that answers. I think your question went way beyond that.
Well, it did. So the rules in a sense have changed, that this jury nullification, a statement of principle, even when the defendant acknowledged that the act took place, that's no longer in the purview of a selected jury, and then that led into the question of what can be done to, I'm not going to say prevent, but rein in what seems to be an entire game of appeals and excuses not to, I mean, in terms of some of our immigrants who are being abducted, the administration apparently pays no attention to the determination of judges because they're going to appeal it to a higher level.
Yeah, that's two components to that. One is jury nullification, and the other is the abuses of the appellate system. Jury nullification is all but unheard of today because we don't see juries as bulwarks against the government bullying people. Most Americans go to jury duty. They're not happy with jury duty, but they go to jury duty. They get paid their $12 a day or whatever. They reach their verdict and they feel that the jury system is generally okay in this country. They have confidence. And from my viewpoint as a judge, I would not be happy with jury nullification. If I said, ladies and gentlemen, this is what it takes to make a contract, and they said, we don't care what a contract is, we're gonna do what we wanna do. Or I say, here's how murder is defined, and they're gonna say, we don't care. Unless, of course, if the government is bringing on a phony prosecution for murder, but within my lifetime, I've again seen that. It's only in the last era that the appellate process, after judges make rulings, that it gets appealed and appealed and appealed, and more time and more time and more time. But there's a structure of appeals in the United States that for 200 years was not abused and not ignored. and not creating constitutional collisions. And we're witnessing some of this now where rulings of courts are ignored. I think there was some person who was being considered for a judgeship, and one of the members of the Senate said, isn't he on tape as saying that that rulings should be ignored and you can do whatever you want? And this guy now wants to be a judge? Not so fast. So I think there's some of that going on now that people are being alert to. I'm not worried about jury nullification. The question of abusing the judicial process to make it endless before something sticks is daunting and is tiresome. And we were not, our due process was not designed to be hasty. All these due process, that you've got to dot every I. We didn't imagine that by making people dot every I, that it would be abused. It was not designed against abuse. It was designed for protection. And we've never seen this before. I guess we'll get through it, but not easy. Yeah, absolutely.
To get back to Peter Zenger, Delancey was acting governor for a period of about 9 years. He died in, I believe, 1760, if somebody has a smartphone. But we'll go back to Lewis Morris. His backers, this starts sort of the two-party system. You have the Morrisites and you have the Delanceys. And this goes by 1750, you have three lawyers that are, William Livingston, William Smith Jr., and John Moran Scott. And they, without freedom of the press, they are pushing, for their agenda and stuff. And that goes right up until the Stamp Act, and it's so relevant today, and it all goes back to Peter Zenger.
Way to go. Are you a history teacher or are you a historian?
Well, but the most important thing, the reason I'm here is because Peter Zenger was a German that came in that single largest migration in colonial times, which happens 12 miles down the road, where Governor Hunter brought 3,000 people to come. But either one of his parents or maybe both of them, passed away on the way over, and he was apprenticed by one of the only printers in New York, Bradford. So he had the ability when Morris, made him, his newspaper and stuff, and it all goes back, to that trial.
Very good. Now you mentioned William Livingston, which reminds me that Columbia County is the home of the Livingston. So this is another great place to visit. The Livingston family was an extraordinary family, along with like the Adams family, the Jay family, Livingston family, great public officials. Chancellor Livingston, one of the great judges of New York and America. So there's the estate up there, the Livingston estate. I imagine some of you visited. You're shaking your head. Yeah.
John Jay married a daughter of William Livingston.
Fascinating. Jay, part French Huguenot, part Dutch, English. So
they all went to school together. Jay, Chancellor Livingston, and everything.
They all went to school.
And
to the John Jay College of Criminal Justice in New York.
He married William Livingston's daughter.
You want to say something? Yeah, please.
John Jay married William Livingston, who was first governor of New Jersey, state governor of New Jersey. He married his daughter. So that, I knew. But I just wanted to bring up a point about the Dutch and segueing into English law and everything. And I think a lot of people misunderstand about tolerance, religious tolerance, because it's freedom of conscience. And that's an extremely important idea at the time. I mean, we take it so for granted today that we don't understand what a really difficult concept it is, that you cannot be prosecuted for your thoughts. You can be prosecuted for your actions. So, for example, the Roman Catholic Church was outlawed in New York from 1691 up till the 1777 Constitution. But you couldn't be prosecuted for thinking as a Catholic. You could only be prosecuted if you tried to form a congregation and worshiped openly. But I think that's a very important thing. And it brings in a lot of questions, too, about the juries and everything, and how the Dutch dealt with these issues, and how it's moved into the English period. Anyway, that's...
Yeah, good. Thanks, Dan. Yeah. Yeah.
I have two questions, I think. I think I heard you say that religious officials could not serve in the government.
Under the, that's not true anymore. I think
that was my
today,
question.
yeah, I think
That's
today,
what we
yeah.
have.
You can have, a minister can be in the government, but we were so mindful of it at that time in 1777 that we wrote it in the Constitution of 1777. Today, that was probably repealed. I don't know. I'm just guessing. My instinct tells me that a clergyman can be a member of the legislature, but I really don't know the answer. Anybody? Go take out your little handhelds and see if that provision was repealed. It's all AI now. You can ask Google the AI anything, and I find that there's reason it's enough to get you a start. So I don't know if that's been repealed. What do you think, David? Has that been repealed?
I think so.
It would seem
yeah,
so.
I think there are clergy
It would seem
today,
so.
but I'm
But
not...
it was really a stride for separation of church and state. And it meant a lot at the time. But when you look at it, you said, my goodness, they really meant it. It was not just empty. And John Jay goes down as one of the great Americans of all time. First Chief Judge of New York, after we were born in Kingston in 1777. And when they needed a Chief Justice of the United States, they said, oh, yeah, how about you, John Jay? Imagine the trust that people must have had in John Jay when they said, oh, we need chief judges. Okay, come on. Here's one guy everybody trusts. Pretty good. Yeah.
1846 was the repeal of the prohibition.
It was repealed in 1846. Fascinating. Good going, Gully. In 1821, for some reason, not for some reason, but for good reason, that was almost 50 years after our first state constitution, we put in a Bill of Rights in New York. And in 1846, we started doing other things, the Erie Canal, and we started, I think, Gully, if I'm not mistaken, 1846 or the next Constitution, 1894, was one of New York Constitution's greatest provisions of all time, forever wild. That has stayed with us. And anytime anybody wants to take a leaf off of a tree, there's a lawsuit, and Forever Wild says, don't touch it. So that was also maybe around that same time. 1846, or maybe 1894. Anyway, we had 5 constitutions in New York: 1777, 1821, 1846, 1894, and 1938. Why 1938? The Depression. There were just too many people drowning. We just had to rewrite things and create. We have a right. A constitutional right in the New York Constitution that is nowhere found in the United States Constitution. The right to have 3 squares a day. We have to help the needy. There's a provision to help the needy in the New York Constitution. The United States Constitution has no such language. The United States Constitution has equal protection. If you can help A, you've got to help B. But that's not the same thing as an obligation. Also, the United States Constitution does not guarantee anybody 1 day of schooling. What they do say is if you're going to school A, you've got to school B. But in New York, we have what we call a constitutional right to a sound basic education. That's in the New York Constitution. So when we say we have 2 constitutions, New York and federal, in many instances, the rights of the New York Constitution are greater than those of the federal And that's true often with interpretation. Judges in New York can interpret phrases in the United States Constitution and the New York State Constitution that are identical, but New York judges can say we're according greater rights under that same language. The right to counsel is same language in both constitutions, New York and US, but we've extended it far greater and in far other situations than in the United States Supreme Court and the federals. That's an interesting little feature about state constitutional law. You're also asking about picking juries and picking judges. Juries are picked out of a hat. It's an honest business. Judges try to keep it honest by seeing to it that the jury pool is representative and that the Commission of Jurors uses every available list so that we don't have jurors that are lopsided one way or the other. We also have rules for juries, one of them from a case called Batson against Kentucky, or it was Batson, I'm not sure it's Kentucky, it might have been Kentucky, in which if the judge sees that the government is eliminating too many blacks from the jury, excusing too many so as to have an all-white jury, the judge will step in and stop it. That's also comes up out of the Equal Protection Clause of the United States Constitution and the state. Yeah.
Were there libel laws against politicians being libelous towards ordinary people?
I'm sorry, can you remember that again?
Were there libel laws against politicians committing libel against individual people, not politicians?
Well, we have libel laws. If A libels B, that could be actionable in a civil case. We still have slander and libel. If you make a false accusation against someone that's libelous in a civil case, you can sue them for saying bad things about you. Truth is a defense. But the harder issue is saying bad things against the government, and to what extent can we do that? And that's been decided in a case called Sullivan against the Times, where you need something close to outright falsity and bad motivation. I don't want to get into Sullivan against the Times because it's a very complex case, but if anybody wants to know the criteria for what you can say against the government or against a government official, just go to your little thing there, handheld, and say, Sullivan against the Times, what is the test? And it would word the test appropriately, I'm sure, to get to the right source.
She's asking if there's any law about a politician libeling a regular person.
Politicians are subject to libel laws just like anybody else. A libels B, subject to libel. Politician libels B, same standards. Politicians have no greater rights, why should they, to libel anybody and accuse them of a loathsome disease falsely. We do have another little thing, and this is interesting. Some of you may be wondering, this business about, is truth a defense? Does that mean that you and I are free to get up and say anything about anybody as long as it's true? Not really. Let's suppose you have some dark secret that's nobody's business, and you've been concealing that. And I find out about it. Am I allowed to put up a billboard in Times Square and hold you up to endless embarrassment just because it's true? No. We have a proceeding in New York called intentional tort. So if anybody takes information against anyone else, even though it's true, and does it for the purpose of intentionally causing emotional harm to that person, that's a valid lawsuit. So you cannot get up and say anything you want about anybody, even a public official, but you can go pretty far in criticizing public officials because political speech is much more valued than other kinds of speech. Does that make sense?
Yes.
Political speech, that is the high currency. We want people to be able to criticize the government. That's how we get better. Ideally speak, the government is never happy about it because it's just not human nature when you're in charge of the government to say you're even a good person, maybe like John Adams. But if you get thin-skinned, you don't like being criticized if you're in charge. If you're the principal of a high school and people are calling you names and you want to do the right thing and people are criticizing you, you don't like it. It's human nature. So when it comes to political speech, we have you got a very wide swath, as it should be.
When you're talking about speech in general, we had this issue with
Yeah,
the
I
young
think
Palestinian student at Columbia, and the government was saying that because he was not an American citizen, he didn't have the same rights as Americans do. But doesn't the Constitution or our legal system say that whether you're an American or a foreigner, you're still allowed to?
Yes, you can get up on the soapbox. You can get up on the soapbox. And again, this goes back to the British. Marble Arch. Am I right? Marble Arch, Gully? Can you tell us a tiny bit about Marble Arch? To me, is that's where in England they say anybody can stand up on Marble Arch and talk politics and say whatever they want to say. Gully, can you tell us about Marble Arch? Gully's a European scholar. I don't want to put you on the spot.
You too.
Huh?
Thank you very
I'm from
much.
London.
Oh, you are? Can you tell us about Marble Arch?
Well, it's Hyde Park Corner.
It's in Hyde Park.
It's called Hyde Park Corner. It's very close to Marble Arch.
Yeah.
And it's a place where anyone can stand
And say whatever they want.
Yeah.
And there's usually somebody up there, what, like round the clock?
Not necessarily, but weekends are kind of busy.
Ain't that, to me, I mean, that's bone chilling. That's just so great. This is what we get out of England. The idea that you can get up and say things.
Yeah, ridiculous things.
Ridiculous, yeah, because we should be able to tolerate stupidity. We're not going to be the judge of what's stupid, because then next thing you know, what you think is stupid and what you think is smart, someone may disagree. And we don't want to give anybody that power. Gully, were you going to say anything?
No, I defer to, since
Okay.
I come from a different province.
Hyde Park. Yeah, Hyde Park, that's right. So it's Marble Arch inside of Hyde Park, is that it?
No, it's actually a corner of Hyde Park.
Okay.
Hyde Park is right next to Marble Arch.
Oh, I see, okay.
Marble Arch is basically a traffic circle now.
Okay. Well, God bless the Brits for
It's
paving the way for.
above the traffic these days, I think.
Right.
Besides which, people, now do you want to dive into social media then, Judge? Because besides which, that's where people are posting their ideas, many of which I think one would claim would be violations of other people's freedom of speech. And so what are the controls? I mean, you did allude to the abuse of the appeal, but what are the controls then in terms of protection? I mean, arts organizations are being denied funding because they're not prepared to accede to a series of essentially exclusions of expression, and they are losing that. What can be done? I mean, suits are being brought to try to restore standing, but then threats are made against nonprofit organizations that they will be investigated and deprived of their nonprofit status if they don't happen to agree with the ideology of the administration. So I mean, that just seems to be a creeping, not so slowly, a toxin, like a constitutional pandemic. What can be done to protect?
There are three ways. that James Madison designed won the ballot box, which the ballot box is the ballot box. The last couple of elections, as we all know, were valid elections. And we elected whoever we elected in a democracy. So we can replace people with the ballot box. The other protection is by the Supreme Court, which some people agree with, and in the minds of many Americans have failed us, some of us, not all of us, and that's a matter of opinion. The other is that the Congress would have the power when it comes to funding the arts and when it comes to going into universities and threatening to cut off funding, federal funding. This is something that Congress can fix in an instant. There's virtually nothing that an executive can do that the Congress cannot undo, because it is the people's house and the house that has the money. It is the money house. So it's a question of getting the Congress to act. And that, unfortunately, has not happened. James Madison might have been puzzled by that. He might be scratching his head about congressional inactivity or how one branch of government has transcended the others. They were supposed to be acting co-equally and checking the others, and for a very, very long time it worked pretty well. But it requires a Congress to act as the first branch of government. Congress is the first branch, not the second branch, not the third branch. It's called the first branch for a reason. Gouverneur Morris used the words, "we the people." That's the Congress. So it's a question of, again, the ballot box it ultimately comes down to the voters. Anybody have some other ideas? I don't know.
What happens if the ballot box is compromised, as it's happening here,
If the ballot box is compromised,
with seizures and preventing people from voting and
Well-
gerrymandering?
well, gerrymander's been around for a long time, and that's politics. The courts can help that out, and these battles are raging in every state court.
Removing places of where people
Yeah.
can poll in large cities,
Yeah.
all suppressing the vote?
Making it hard to vote, making it hard for certain people to vote.
Yeah.
Yeah, that's part of the struggle. I don't know that it's unprecedented. I think there's been tampering with voting before in our history, but all these things piling on at once, where some of this is uncharted for us as Americans. The business about making it hard to vote for some people, I don't recall anything in my lifetime like that, quite like that. But the remedy is with the courts, likely is not in the state courts. And these battles are going on in the state courts as we speak.
Well, that's what Jim Crow was
Well, like Jim Crow. Yeah. And some of that stuff,
in our history.
that also gets rhyming. I think by and large we made great strides when it comes to equality compared to where we were 150 years ago, but we still got a long way to go.
In your opinion, are the statements that DHS and the president that they're making about me good? Do you think that's libelous?
Presidential statements would not be libelous, no. I mean, the president,
What about the DHS secretary?
libel means making the libel laws are not designed to cover executive speech. Libel is between two private citizens. One person says something false and inappropriate about another, can bring a civil suit for libel. But executives, mayors, county executives, governors can get up and say and speak lies. Hopefully it's not often, but telling a lie is not libel. It's a lie. It means that the next time around, you're not going to vote for that governor or that mayor or that school board person or that village board trustee. You just don't vote for that person if the person's a liar. I mean, that's human nature. We live by those criteria.
What's the difference between libel and defamation?
Defamation covers libel and slander. Libel generally, historically, refers to writing, slander, verbal. But they both fall under the heading of defamation. So we use the word defamation now because it's so like what is spoken and what is written. In today's world, you can make the argument that something is spoken over the internet, it's spoken here and there, is it written? So hard to know. That's why we simply say defamation, and it includes both. Wow, I think we've held you folks long enough, right? We had David?
It was wonderful.
Okay.
Yeah, wonderful.
David,
Thank
what do
you
you
so
think?
much.
Okay, good.
Yes.
Thank you.
It was wonderful. Do you want to put anything to say? All right. Well, I think this has been a great presentation and great questions from everybody, and I'm really glad that you've all turned out for this presentation.
Yes.
So, thank you.
I forgot to tell you where the water is. I have water.